The Supreme Court and the question of freedom, how one case could change the meaning of home privacy forever. In the heart of the United States justice system, a new case has reached the Supreme Court, one that could quietly redefine what it means to be safe in your own home. The case, known as Case v. Montana, might sound distant to many people, but its outcome will influence the boundaries between government power and personal freedom for decades. The hearing is scheduled for October 15, and the entire country is waiting for a decision that could determine whether the walls of your house still protect you from the state or whether they can be crossed in the name of reasonableness. At its core, this case is about the right to privacy and the Fourth Amendment to the U.S. Constitution, which protects citizens against unlawful searches and seizures. The principle is simple, but sacred. No one, not even the police, may enter a home without a warrant unless there is clear and immediate danger. Yet now, the Supreme Court is being asked to decide whether that right can be weakened under the vague concept of emergency aid. If the court sides with the state of Montana, it could open a dangerous new chapter in which law enforcement can step into private homes based on little more than a feeling or suspicion. The case sounds like a debate about law, but beneath the surface, it is about power, who has it, how it is used, and what happens when fear replaces freedom. The story began when a man named Trevor Case found himself the target of police suspicion after his ex-girlfriend called the authorities. She told them she had a bad feeling after speaking to him and feared that he might harm himself or the police. Her words were uncertain. She could not even recall exactly what he had said. But those vague statements were enough to send 4 officers to his house. They arrived, looked through the windows, and saw an empty gun holster and a notepad. For 40 minutes, they knocked, called out, and shined flashlights into the rooms, but no one answered. Then, without a warrant, they opened the unlocked front door and entered his home. Moments later, an officer fired his gun. Trevor was hit in the arm and abdomen. The officer later admitted he shot after seeing the curtain move and just let one fly. This moment is at the heart of the case. Did the police have the right to enter that home? Did fear justify a shot fired in darkness? The lower courts said yes. The Montana Supreme Court ruled in a narrow 4-3 decision that the officer's actions were lawful under the emergency aid exception. But Trevor Case argued that his home was his castle and that the police violated the Constitution by breaking in without a warrant or clear probable cause. His argument reached the U.S. Supreme Court, which will now decide how far the Fourth Amendment extends when the government claims to be acting for your own safety. This is not the first time the Supreme Court has faced such a question. In 2021, the court unanimously ruled in Coniglia versus Strom, another case involving warrantless entry and firearm confiscation. In that case, police officers entered a man's home after his wife expressed concern about his mental health. The officers took his guns even though he explicitly told them not to. The Supreme Court ruled 9-0 that this so-called community caretaking justification could not be used to enter a home without a warrant. It was a powerful statement that the home remains sacred and government convenience cannot override constitutional rights. But now, only a few years later, the same issue has returned, disguised under a different name. The state of Montana and the Trump administration, which has been granted permission to argue in the case, are asking the court to adopt a looser standard. They claim that in emergencies, police do not need probable cause. Instead, they only need to act reasonably. That word may sound harmless, but in law, it is dangerously vague. What is reasonable to one officer might be abuse to another. A rule built on such uncertainty turns freedom into a privilege granted by the mood of those in power. If the Supreme Court agrees with Montana, it could mean that an officer's personal judgment, not solid evidence, becomes enough to justify entering your home. A strange noise, an unanswered phone call, or a worried neighbor could become the legal keys to your front door. This is what makes the case so alarming. It is not just about one man or one state, but about how easily private life can be opened to public control. When the law begins to bend under fear, it rarely stops at one exception. The Trump administration's legal argument makes this even clearer. Their brief claims that probable cause only applies when a warrant is required. Because emergency aid actions happen without warrants, they say. The only rule should be reasonableness. But this reasoning turns the Constitution upside down. The Fourth Amendment was written precisely to limit such unchecked discretion. It exists to ensure that before the government enters a person's home, it must prove necessity, not convenience. Reducing the standard to reasonableness invites subjectivity, error, and abuse. It allows power to act first and justify later. Trevor Case's lawyers responded strongly, arguing that the simplicity of probable cause protects both citizens and officers. They pointed out that even the Trump administration and the state of Montana cannot agree on how to define reasonableness. How then can ordinary people know what the law allows? When rules are unclear, rights become fragile. The line between emergency response and unlawful invasion begins to disappear. The home, once considered a place of safety and independence, risks becoming another space where government authority can reach without warning. For many observers, this case is about more than legal definitions. It touches a deep human fear, the fear of losing control over one's private space. Throughout history, free societies have defined freedom by the idea that one's home is untouchable without cause. The English jurist William Pitt once said, "The poorest man may in his cottage bid defiance to all the forces of the crown." That belief carried into the American Constitution. Yet today, that promise feels uncertain. The growing power of the states in the name of safety has already pushed the boundaries of surveillance, policing, and data collection. Case versus. Montana is a reminder that freedom often disappears, not through sudden tyranny, but through small exceptions made in moments of fear. The emotional weight of this case also lies in its human tragedy. A misunderstanding, a phone call, and a decision made under pressure turned into violence inside someone's home. What was meant as protection became an act of harm. Whether or not the officer believed he was doing the right thing, the event shows how fragile justice becomes when it is guided by instinct rather than law. If reasonableness replaces probable cause, such tragedies could become more common. Officers would be left to interpret emergencies on their own without clear limits. Innocent people could find themselves at the wrong end of a weapon simply because someone had a bad feeling. The legal scholars following this case warned that it could erode one of the oldest legal protections in Western law. The idea that a man's home is his castle is not just a phrase. It is the foundation of privacy, autonomy, and dignity. Without it, citizens live not in homes but in temporary shelters, always vulnerable to intrusion. The case forces society to ask a painful question. Do we value security more than liberty? And are we willing to trade one for the other? There is also an international lesson in this American debate. Many countries, including China, are watching how the US handles the balance between state authority and personal rights. The outcome will shape global discussions about surveillance, police power, and human freedom. The principles at stake, privacy, due process, and the limits of government belong to all people, not just to one nation. When a leading democracy begins to blur the boundaries of its citizens' privacy, it sends a message that fear can justify anything. That is why this case, though rooted in Montana, echoes far beyond its borders. The coming weeks will reveal how the Supreme Court interprets this challenge. Legal experts expect intense questioning during oral arguments, as justices explore the meaning of emergency, reasonableness, and the true intent of the Fourth Amendment. Some predict the court will maintain its previous position and protect the standard of probable cause, especially after the strong 9-0 ruling in Caniglia versus Strong. Others fear that a more conservative or security-focused court might lower the standard, allowing greater flexibility for law enforcement. In either case, the decision will define the limits of police power for generations. The possible consequences are chilling. If the court approves the reasonableness test, the definition of privacy will shrink overnight. Police departments across the country could reinterpret the law to justify warrantless entries in a wide range of cases, from welfare checks to mental health calls to vague safety concerns. Once these new powers are granted, history shows they are rarely taken back. The walls of one's home could become paper thin, not because of criminals or invaders, but because the law itself stopped protecting them. Yet, there are ways forward that preserve both safety and liberty. The first step is to reaffirm that emergency exceptions must remain truly exceptional. Probable cause should not be replaced by reasonableness. Instead, the standard can be applied with sensitivity to genuine emergencies while still demanding evidence and accountability. Police training must emphasize constitutional awareness as much as tactical response. Officers should be equipped to handle uncertainty without defaulting to force or intrusion. Moreover, transparent review processes should follow every warrantless entry, ensuring that citizens have a path to challenge abuses. Public awareness also plays a crucial role. People must understand their rights, question the expansion of state power, and demand that safety not come at the cost of freedom. Fear is a powerful weapon, but history shows that societies guided by fear often lose both safety and liberty. Education, open dialogue, and civic vigilance are the only defenses against the slow erosion of rights. The conversation around case versus Montana should not be left to lawyers and judges alone. It belongs to every citizen who values the sanctity of home. The case also reminds us that freedom depends on limits, even for those who protect it. Police officers face real dangers, and their duty to respond to emergencies is essential. But that duty must be guided by law, not instinct. The rule of law exists precisely to prevent moments of panic from turning into permanent policies. True strength lies not in how much power the state has, but in how responsibly it uses it. As the Supreme Court prepares for its decision, the world watches a nation decide what freedom means in the 21st century. Will the justices uphold the principle that a home is a place of peace and privacy guarded by law and conscience? Or will they open the door, quite literally, to a new era of intrusion, justified by reasonableness and fear? The answer will tell us not only what kind of country America is, but what kind of world we are building together. In the end, the most shocking truth is this: freedom rarely dies in darkness. It often fades under the bright lights of good intentions. When the state claims it is acting for your safety, it can be tempting to accept its power. But safety without liberty is not protection, it is control. As citizens around the world reflect on Case versus Montana, the message is clear. Rights are not lost all at once. They disappear one exception at a time. The only real safeguard is awareness, courage, and the unshakable belief that a person's home, no matter how small, no matter where, is a place the state may never enter without true and proven cause. If societies wish to avoid a future where the front door means nothing and privacy becomes a memory, they must demand clarity, accountability, and respect for the principles that protect them. The solution is not to reject security, but to remember that security itself is built on the foundation of law and freedom. The Supreme Court's ruling will decide more than one man's fate. It will reveal whether the world's oldest democracy still believes that liberty begins at home,